Welcome to this presentation that addresses a fundamental issue. When does an employee's invention become owned by their employer? Whether specialising in the legal field or not, this issue affects nearly all industries where there is a possibility to invent in the course of employment. Australia has no current patents legislation that cover an employer's right to an invention made by their employees. Therefore, the first step is to analyse the contractual relationship for express terms regarding ownership matters between an employer and employee. If the contract is silent on invention matters, one must look to the common law principles. In the early to mid-1900s, the court's position was generally that an invention made by their employee in the course of his or her employment will belong to their employer and should be disclosed to their employer. The meaning of in the course of his or her employment has its limitations when considering other variables. For example, in Electrolux and Hudson and Quantum Corrective Services Commission of Queensland, it was found that if an employee makes an invention and is not employed to do so, even if they make it in their own time or during their employment, they can still claim the right to an invention. Furthermore, the invention is still an employee's if it was created without using the owner's equipment. Subsequently, new variables were progressively accepted by the courts as determinants of who in fact owned an invention. Justice Nettle summarised that if an employee makes a discovery or an invention during the time of his or her employment, doing what they are hired and instructed to do, and during working hours using the employer's materials, it is ultimately the employer's property. Therefore, in a case that can be identified as the turning point of the court's perspective on employee-employer ownership of inventions, in the University of Western Australia and Grey, the court found that if an employee's duties involve using their inventive faculty for the benefit of the employer, ownership of the invention is implied in the contract to be the employer's. Essentially, where job descriptions require employees to design or draft, it is likely that any subsequent inventions or discoveries will belong to the employer. A duty to invent, however, is different to a duty to research. It is not enough that an employee is obliged to conduct research, or even that inventions are a foreseeable result of research. Rather, the difference in the two duties is that when there is a duty to research, researchers are free to choose the subject or line of research and decide when and how to publish it. On the other hand, a duty to invent commonly bears on those who invent in an employment arrangement to keep such discoveries confidential, so the employer can maximise on any competitive advantages. Ultimately, the notion of an employee's inventive faculty for the benefit of the employer will only be in favour of the employer if the purpose of hiring the inventor was to clearly invent, as seen in Royal Children's Hospital and Alexander. In this case, a hospital was entitled to an invention created by their senior scientist, who was employed to identify potential areas for improvement in the hospital's diagnostic service. So what does this all mean for employees? In conclusion, being familiar with these determinant variables of ownership before pursuing any inventions for personal gain is a practical safeguard, particularly when there are in fact express terms in the employment contract. If there are no express terms, it is imperative in all employment situations to be clear what the primary job role is.